it down. With Shizzy, Wiz, Nut.
An open letter to the paper fortress on futility, smoke-stained citations, and the art of mailing it all in. Dear keeper of the mailed brief, what you call an opposition reads less like a law and more like the diary of someone who half-watched courtroom drama while dozing.
I wasn't paying attention, man. I looked up, you get your helmet on, and I lost it.
You wield the word futility as though it were a charm, convinced that if you say it enough times, reality itself will rearrange. But repetition is not reasoning. An argument is built on facts, law, and logic, not from your hollow declarations scribbled like graffiti across a pleading. The court cannot persuade you by your insistence alone, no matter how many times you pound the table and mutter the same word. The laziness saturates every page. Each line looks stitched together from scraps you scavenged, phrases taped into place without a care or understanding. It is not a legal argument so much as a collage, a ransom note cobbled together during long pauses, spent staring out the window and wondering when the next smoke break might come. The sentences are as thin as the paper you mailed them on, flimsy, brittle, collapsing under the weight of even the slightest scrutiny. One can almost see the scene, a dark desk cluttered with coffee rings and ash, the glow of a lighter illuminating another paragraph of filler. Thought is rationed in the length of a cigarette, attention spans measured in drags. And the result shows the writing wheezes where it should breathe, meanders where it should reason, and trails off into nothingness where it should persuade. Each argument is smothered before it begins, choked out by its own lack of clarity. Even the structure is heavy and graceless, paragraphs lumbering forward without direction, weighed down by their own repetition. The effect is not sharp or incisive, but bloated like a filling, swollen with water damage, soggy and illegible. Instead of insight, you offered bulk, a lot of bulk. Instead of reasoning, you provided noise. It is the intellectual equivalent of waddling into court unprepared, hoping that sheer presence might substitute for preparation.
I've done that. I'm sorry. I mean, you just throw yourself out there. It's like, man, I'm a mercy kill right now. Sorry.
Beneath all this padding lies the familiar thread of your favorite con. This is not advocacy, it's performance. The same act you run elsewhere, casting yourself as the aggrieved, posturing as though every consequence is persecution, spinning confusion into a shield. Filing is not meant to convince, it's meant to distract from a lazy eye, to buy time, to bluff, a paper scam mailed in like all the others, offering the appearance of effort while delivering none. So when you say futility, the word rings true, not in the plaintiff's claims, but of your own attempt at persuasion. Futile is the pretense, futile is the strategy, futile is the belief that by stringing together smoke, excesses, and half-phrases, you could pass it off as law. You mailed this brief not just because you lack electronic access, but because every part of it is mailed in spirit and in fact. And then comes your great performance on relation back, which is not so much an argument as a scavenger hunt gone wrong. You stumbled across a few case names, glued them onto the page, and called it analysis. But like everything else you touched in this filing, there's no structure, no reasoning, no understanding, just case names tossed around like confetti at a parade, shiny for a moment and then swept into the gutter with the rest of the trash. You drag out mail like as though it's your ace card, when in reality it's nothing to do with the matter at hand. It is a habeas case, and you dropped it here like a drunk clutching the wrong set of car keys, insisting the engine will turn over if you just jam them hard enough into the lock. It doesn't fit, and everyone can see it. What this shows is not diligence, but desperation. You aren't searching for authority. You were searching for anything with the right words in the caption, and you stopped the second you found it. Never mind what it actually said. That isn't law. That's laziness dressed in citations. And then comes your mangling of Krupski, which might be the single most embarrassing part of this entire mailed-in circus. The Supreme Court, in plain language, explained that misunderstanding a party's role is a mistake that rules correct. That should have been the end of it, but you, too proud or too stupid to admit that the case actually says twisted into the opposite, while you declared without shame that the plaintiffs knew all along and therefore had no right to fix it. Well, that's not advocacy. That's lying to yourself on paper and hoping the court plays along. Worse, it's lazy lying, the kind so easily disproven that one wonders if you even read the decision you cited or if you were too busy lighting another cigarette to bother. The entire section reeks of laziness and arrogance. And there's no attempt to build reasoning, no attempt to engage with the facts, no attempt to actually explain how these cases apply. You simply pasted their names into the brief, leaned back, satisfied with the illusion of effort. It is the same trick you pulled everywhere else. String together borrowed words, puff yourself up, which doesn't take much, and pretend it adds up to substance. But when what you mailed in here, it's not substance. It's hollow like your mind, and it's filler like your lips. It's intellectual equivalent of sending the court an envelope stuffed with shredded newspaper and hoping no one notices the weight is fake. What you called an argument is nothing more than your habits bleeding onto the record. Cut corners, avoid effort, and mask it all with volume. The smoke from your Marlboro clouds the room, but not enough to hide the emptiness of what you've written. You lumber from one page to the next, padding it with repetition, convinced that if you fill enough space, the court might mistake it for seriousness, but the truth is heavy, and your work collapses under its weight. This isn't law, it's theater, cheap theater at that, the kind with cardboard set and actors reading lines that they don't understand. So once again, the futility here is not in the claims that brought against you, but in the hollow spectacle you mailed to the court. Futile is the way you borrow words you don't comprehend. Futile is the way you twist cases into shapes that were never meant to take. Futile is the belief that anyone, least of all a federal judge, will look at this smoke-stained cut-and-paste mockery and see anything more than what it is: laziness stapled together, sent through the mail, hoping the envelope would disguise the rot inside. By the time we reach the later pages of your mailed-in opus, the collapse is complete. What began as an attempt to throw around legal buzzwords ends as nothing more than procedural whining. The written equivalent of stomping your feet and demanding that the court recognize your personal discomfort as law. You insist that the motion is substitution fails on procedural grounds, as if the rules themselves will rise up in your defense, but your understanding of those rules is as thin as the paper your ink bled into. You mistake form for substance, process for power, and you seem to believe that if you shout procedure long enough, the court will forget the very reason these rules exist, to prevent exactly the kind of games that you're playing. Then there's this chorus of bad faith. You throw those words around like confetti, certain that volume substitutes for evidence. Plaintiffs acted in very bad faith, you say. Plaintiffs delayed, you cry. Plaintiffs misled, you insist. Yet, when pressed, your accusations evaporate. There's no proof, no detail, no example, just the same tired refrain you've hummed for months. That everything against you is unfair, that everyone else is corrupt, and that you alone are the victim. It's not an argument, it's self-pity dressed up in italics, mailed in like everything else, and the court asked for a response, and you delivered a diary entry. And then perhaps there's the most anticlimactic finale imaginable. You close not with a conclusion, but with a limp request. Not a summary, not trying to tie together all the points, not even a final attempt at persuasion. Just a line asking the court to deny the motion as though the preceding pages had earned you the right. It reads less like the ending of a legal brief and more like your shopping list hastily scribbled on the back of an envelope. Milk, bread, deny plaintiff's motion is a kind of ending that betrays exhaustion, the kind that says you were out of words long before you ran out of paper. And of course, all of it arrives the same way you deliver everything else, not through the modern portal of electronic filing, but through the post office, because even the court decided you cannot be trusted with the tools that everyone else uses. So your arguments slip into the courthouse, days late, paper crumpled, ink fading, the smell of smoke clinging to every page. Futility, bad faith, procedure, all bundled up in a manila envelope and shoved through a mail slot, hoping the delivery itself would disguise the fact that the contents are empty. So here you are, standing at the end of your own brief, not with a crescendo, but with a whimper, no reasoning, no substance, no conclusion, just the mailed-in echo of your own laziness. You called it a request. The rest of us call it what it is: surrender, sealed in an envelope and sent with exact postage. Still as frosty as a pumpkin in December, Shizzy Wisnut, shill riding that short bus through your mind.
It is about time. Let's break this mother down. With Shizzy Wisnut.